Reactions continue to trail the September 6 judgment of the Presidential Election Tribunal in 3 petitions challenging the return of President Bola Tinubu. This week, I have the views of a senior legal practitioner, the pioneer chairman of the NBA section on business law and life bencher, Judge Etomi, on the judgment and other issues.
My initial reaction was that it was a very detailed judgment. I listened to as much of it as I could. And then I've been reading the rest. I didn't listen to 800 pages. The feeling I got was that the judges were doing this for history because the polity has become so heated up. There's been pressure all around, especially on the judiciary. And I think everybody in that panel was standing up to be counted so that long after all these pass away, when students of history, when posterity is beginning to judge people, there are records by which they will be judged. So I'm not surprised that it took the length of time that it did. In the past, what you would have done is they would have told you what the verdict is, and then they will tell you the details will be supplied later. But they were not going to do that. They needed to take each of the issues one by one, and then to convince let me say, the electorate, because this is all about the electorate, why they were coming to the conclusion they were coming to. Now, whether they're right or wrong, since the matter is going upstairs, we will know. But when you begin to look at the specific issues, I mean, the major planks upon which this decision was taken was they separated things they considered pre-election matters and then to the actual election matters. And the pre-election buckets were like, these issues you have raised should have been raised before the elections started. You didn't raise them. It's like an ambush tactics to now squeeze them into an appeal. And in their opinion, it was taken away from the gravamen of the main action. If you had raised it, it was dealt with, perhaps the consequences would have been known. But now you've gone to do an election. The electorate have voted. What we should be looking at is that, were these elections properly conducted? Did it meet the substantial compliance threshold? Were the results fairly representative of the wishes of the people? And that's really what should be the issues to be discussed. Now, if you allege that there were malpractices in certain polling units and all that, the standard is he who alleges proves. So you must bring all the necessary proof to convince. That's just the first step. The second step, then, you go on to ask the question, assuming you are right, and this is corrected, would it have affected the outcome? So those were the 2 tests. And in the opinion of the judges, the petitioners didn't meet those thresholds. If they had met it, perhaps the outcome would have been different. But having said that, the burden of proof placed on petitioners is, in my opinion, unduly burdensome. In the sense that most of the materials they require to prove their cases are with the umpire, in this case, INEC. So if INEC shows up more like a nominal party, as opposed to the party against which most of the complaints should be made, then it's a problem. So shifting that sort of burden could be a problem. In the minimum, INEC should be compelled to make records available and to all sides. Let them see how you conducted this election. And then if they need to pick holes, INEC should actually be the ones to come and explain why things were done in the manner they were done. And if the justices, in their opinion, feel that INEC has not met the threshold, they can make a pronouncement. But I haven't said all that we have said. We must not run away from the fact that our politicians see this democracy as an end in itself, which is so sad. The democracy was supposed to be a peaceful way of deciding who governs the affairs of our people. Today, good governance is in the background. Even the time it takes to settle election petition issues. I mean, it's almost like from one cycle of election to another. So nothing else is happening anywhere else. We are not seeing example of good losers. Perhaps the last time we saw one good example of good losers was in the Jonathan era. Jonathan was pushed to contest the election that he lost. And he just rose above the fray. And I'm just a bit disappointed that that good example has not been followed. It is not every time you lose that you must try and bring the house down. You can protest, but you must be measured in everything that we do. But today, we're not measured. Everybody holds on strongly to the belief that they won. And it's like, if it is not my way, it must be the highway.
So I hear what you say about pre- and post-election issues. I hear what you say about the burden of proof that's placed on the petitioner, which appear to be so high. I hear what you say about the fact that, there's sometimes a lack of sportsmanship in some respects. But I'm just wondering, what does this say about our laws? Because on issues which you have controversy, it appears that the law is not certain. I've even heard some lawyers say that the Electoral Act is under trial. So what does it say about our laws and precedents? Is it that there's uncertainty, and which is what is giving rise to all of these issues?
Let me say something. You see, laws are what they are. You cannot provide for every minute detail in a law for it to be certain. And that's why you have rules of interpretation, because you can only put so much in the law and then leave it to interpretation. So in the end, it comes to the people who run these laws. The Electoral Act was amended after so much cry. Let's start with the electronic transfer, uploading, and all whatnot. And people assumed that that had been taken care of. Now, from this judgment, some people are claiming that that electoral amendment comes to naught. It's a major setback. But if you look at the wordings, it only just requires, and INEC has to have a discretion. And the reason they must have a discretion is that electronic gadgets can fail you. You can use the BVAS for your accreditation. You can do your IREP for uploading and go. Collation is a totally different matter. For me, what matters is that if what you've collated, whether you collated manually, conflicts with what is stored electronically, if you provide that clear evidence, I'm sure the judges will overrule it. But if you merely allege that because that uploading was not done for whatever reason, I'm not justifying it, that it now meant there has been such fundamental breach, cancel everything, make a rerun, that would be an overstretch. Because quarrels, disagreements must end. If you look at the spread, let's even be logical. Between the PDP and the LP, as we've seen now, if they had actually been one party, they would have won this election hands down. So does that not count for something? So why isn't somebody realizing that that split weakened them? And then suddenly the person who had the most votes out of the three of them becomes the bad guy. This is just broad logical thinking. And then why do you then assume that all those who voted for the current president, their opinions also don't matter? I think the admonition here is that we must all be measured. On the subject of Abuja, what the law said that Abuja should be treated as though it were a state. Abuja is not a state, but it should be treated as though it were a state for certain purposes. And for the purpose of the elections, when you are counting the spread of votes, you must include Abuja as though it were a state. But because it is not a state, the law had to say 36 states and Abuja. It was, if anything else, it was to emphasize the fact that it is not a state, but should be treated as a state for this purpose. In other words, whoever resides in Abuja's electoral vote should not be superior to those of us in Lagos or Kaduna or wherever it is. Anything else is an absurd conclusion. Otherwise, like somebody said, we all move to Abuja.
Another thing which you have alluded to is the pressure, which our judiciary came under with this elections, and what some commentators have described as intimidation by politicians and their supporters. How do you think that our judges and the justices can be protected, from some of this undue ridicule that we saw with these elections, even on social media?
You see, because I know so many judges, because I'm on the body of benches and we interact with them, you cannot but feel sorry for them. They don't have a voice of their own. And at times, the people who should stand up to defend them keep quiet in the face of what I call the unfair bludgeoning of our judiciary. These are people, they didn't originate these quarrels. You mess up, you come to them. They act upon the evidence before them. It doesn't meet with what you expect. You start throwing dirt at them. I think it's very unfortunate. And in doing so, we forget that we're denigrating a vital institution in a democratic setting. And the way you read, like you said, in some of these social media, it's almost as if it's a basket case. All judges. I mean, there are a few bad eggs. But like they say, one bad apple doesn't spoil the whole bunch. You must respect that institution. And it is even more damning when it's members of our profession who should know better. We know ways where we can criticize judges. We know the ways they can be disciplined. But to sacrifice them the way we are doing, who are we hurting? Today, as I speak to you, because my background is essentially business law, investments are suffering. And that's simply because when there is a dispute and you need to adjudicate, most of your judges are election tribunals. And like I told you, it's almost like a full election to election cycle. So business disputes are at bay. Elections don't bring money. What brings money are investments. So that's why I said it's almost as if we've lost our direction with regard to this democracy. Democracy is almost like an end in itself. Anytime you turn on the television, you open your social media, is election. I like robust conversations, don't get me wrong. But there's a time and season for everything. You finish, you put the election season behind you, you begin to see how you can attract investments. Today, things are so bad. When the president travels out and is attracting investments, you read, it just depends on what platform you're reading. He's being denigrated. There isn't an effort to say, oh, well done, and all that. So, is election an end in itself? Shouldn't we get to that point where we begin to fix the economy? We are all actors in this country. We'll come and go. We play our roles and go. The country would outlive us. But to behave as if it is not my way, the system should come down, I condemn it completely.
Finally, let's round up talking about agenda setting for the Attorney General of the Federation, the AGF, and even the future of legal practice.
Yeah, I'm glad we're talking about this because these are the things we should be looking at. First and foremost, the admonition, and the AG himself got it, is enthronement of the rule of law. Because it's the fulcrum upon which a democracy thrives. Once you are certain that upon the happening of certain events, this is what will be the result, it creates the stability in a system. So the rule of law, so he must keep to that promise to enthrone the rule of law. And then the benefit of enthroning the rule of law is that it will attract business. We must continue to do our continuing legal education. There is a lot happening within the global investment community. Free trade zones are taking over. We've signed up to the African Continental Free Trade Zone. Various ancillary agreements are being signed. What are we lawyers doing about it? And there are these massive opportunities. At the last NBA conference, I spoke on what they need for lawyers, African Continental Free Trade Area. Because as Nigeria enters into most of these bilateral or multilateral agreements to open up our borders, if we lawyers don't take advantage of it, we will be history. So these are the sort of things we should be doing. We should support the Attorney General. Now, the other agenda, there's so much agenda to set for him, but one of the things I want to look at are these foreign judgments against Nigeria. First of all, I think he should actually go and get a proper register because that thing appears to be a huge racket. And it places a burden on our revenue as a country, because there are so many judgments just sitting and waiting to be enforced. How they were obtained, how they were defended, the P&ID just came to light because of the incidents that I attended to. There's so many more hidden P&IDs. I think he should do an audit. So which means he has to have a robust department that looks into all these foreign agreements, these agreements we go to, that have the potential for creating the kind of mayhem that we have. Because if we lawyers lead society right, if the sound bites that come out of us are the right sound bites, if we measure our language, if we talk, the things we do, we are a beacon, we're a light to society. If we don't manage it well, we will be sending a wrong message.